notice. This was one where,
Ms. Medrano, let me stop you real quick. Let's get on the record since we're on YouTube already. Let me calling cause number 2022 DCV 1479. JP Morgan Chase Bank NA versus Joel A. Cisneros. May I have announcements?
Christy Medrano on behalf of JP Morgan Chase Bank, Your Honor.
And I don't see anyone on behalf of Mr. Cisneros. We are set for a default. Ms. Medrano, you were about to tell me some things about service.
Yeah, well, when I was here last time, there was, you had I believe the court had indication there was possibly an opposing counsel, and I didn't have anything. But I have since reached out to the alleged opposing counsel. On this case, the defendant or the opposing counsel did reach an agreement with our office. Mm-hmm. And in fact, the defendant is making payments and is current to date. The problem is he has not returned the signed documents, which include an agreed judgment, which if he had, I would have filed it with the court and it wouldn't keep coming up on your docket. Mm-hmm. Mr. Burton's office said they reached out to their client and they got no response. So what I'm looking at is it's a little difficult today, I've come to understand, because while I do have the motion for default previously filed, it does not contain an affidavit, and I've been trying to get that from my client, and my client evidently will not do that if there's payments being made in one as of lately as 30 days. So I can try to prove my case with the last statement and the charge-off statement, which do so show, use of the account, a promise to pay and a failure to pay, but I don't have the affidavit. So I best I was going to ask maybe for a continuance and let me try to figure this out.
How much time do you think you need, Ms. Medrano?
I'd say 30 days. I will reach out to the client myself and see how we can move forward on this. We need to get a judgment. And the guy is, he is paying it, but we don't have a judgment. He could stop tomorrow.
Right. I feel like 30 days is going to be too short. I'm going to put you down for 60 days.
Okay.
60 days reset on the default.
Okay. I greatly appreciate it, Judge, and I will have a better answer for you when I see you again. Okay.
And if something gets squared away without the need for the hearing, just let us know so we can cancel it.
I certainly will.
Thank you. You may.
Thank you.
Okay, let's go to the next one.
In cause number 2022 DCV 2001. The Nevada's Law Firm PC versus Perseverance Group LLC and Jesse Ramirez. Now from the counsel, please.
Michael Nevarez for the plaintiff, the Nevada's Law Firm PC.
And I did have shortly before this hearing, got on the record, had a bailiff look to see if Mr. Ramirez was physically outside of the courtroom, and he was not there. Were we able to tell if Mr. Ramirez received the notice of today's motion to dismiss?
Yes, Judge, he opened the notice.
Okay, does it tell you when, Ms. Cables?
March 2nd at 4:44 p.m.
Okay, thank you. Okay. So we are scheduled today for Mr. Nevarez's, I'll say Mr. Ramirez's motion to dismiss, although I know that motion was filed back at the time, were we on default or summary judgment? And so it was, although it was filed, it was set for today, and I believe Mr. Ramirez was present. What I mean to say by that is that the motion to dismiss, as had been an ongoing issue, Mr. Nevarez was filed on his behalf as well as the entity, and of course we have dealt with that ongoing issue. So on the motion to dismiss, the only thing that I am looking at in the motion are the claims that he has filed on his individual behalf. And I do see also that you filed a response, and an amended petition. Let me open that one very quickly. So this was filed, what, 2 days ago? No, I'm sorry, it was filed yesterday. It was filed yesterday. Mr. Nevares, why don't you give me a quick summary, I guess, of what your response is?
Yes, Your Honor. It's first of all, the response indicates that the federal rules of civil procedure are not applicable. It also indicates that Mr. Ramirez's motion to dismiss under Texas Rule 91A is untimely. It doesn't, plus Rule 91A doesn't provide for dismissal with prejudice, which is what he's requesting. It also indicates that it's the 91A motion filed by Mr. Ramirez is defective, and it doesn't address all of the causes of action specifically as required by Rule 91A.2. So it's defective and in error. It also indicates that Texas Rule 165A.2, which Mr. Ramirez bases his motion on in part, is inapplicable because that pertains to dismissal for want of prosecution, which isn't the case. He doesn't allege how I have failed to prosecute this matter or attend hearings or trials on behalf of my client, the Nevada's law firm PC. It also addresses Mr. Ramirez's assertions that he's not liable personally because there's no contractual relationship with the plaintiff's law firm. And I challenge that by indicating that the petition against Mr. Ramirez, it wasn't based only on contractual relationships, but it asserts other non-contractual responses. And so then at most, Mr. Ramirez's motion is only partially pertinent. The rest of the causes of action, aside from breach of contract, should remain. I also indicate that
let me stop you right there, Mr. Nevares, because I haven't seen is that where the amendment on the petition happens, or was the amended petition, what did it amend?
No, Your Honor, the original petition, as does the first amended petition filed this morning, both had 14 causes of action. Only one was breach of contract. And then, Mr. Ramirez failed to address 13 of the 14 causes of action in his motion to dismiss. I also indicated in my response that the original petition, as does the first amended petition filed this morning, assert several bases to pierce the corporate veil, including intentional and willful failure on the part of Mr. Ramirez personally, his false representations to me personally. It just continues on, but those were all of those non-contractual assertions were addressed in the original petition. They're only fleshed out a little bit more in the first amended petition, And then it also updates the default judgment that was issued against the LLC that was wholly owned by Mr. Ramirez. I hope that answers your question, Your Honor.
Okay, it does. Did you say that the amended petition contains a breach of contract cause of action against Mr. Ramirez personally?
Yes, it does. Yes, it does. The agreement between the parties was fashioned as a result of discussions prior to execution of the retainer agreement, where he represented to me that he wanted me to fashion a plan of reorganization to assist the LLC to reorganize, which also included some of the claims against the LLC also were guaranteed by Mr. Ramirez personally. So all of his representations prior to execution of the contract, the retainer agreement, were relied upon me to provide not only the LLC plan of reorganization, but to assist Mr. Ramirez in having refinancing of his personal guarantees, as well as the continued residency by Mr. Ramirez of one of the properties owned by the LLC, which he was using as his personal residence, and in which he commingled as part of his income and assets.
Okay. So to the extent the motion to dismiss pertains solely to Mr. Ramirez, that motion to dismiss is going to be denied. The only thing we're set for today, we'll see. We don't have a final status conference until November. So I know that we will hear from you if you need an additional hearing. We do have an email address, although we don't have a phone number for Mr. Ramirez. So Myrna, when we send him, Mr. Nevarez, if you will email me the proposed order, just denying the motion to dismiss. If you can include some language in terms of the specificity that the court only considered the portion, the motion to dismiss that pertained to Mr. Ramirez specifically, I think that would be helpful to continue to make that clear. Then we can get that filed, and we will email, if we have a mailing address, great, that along with Mr. Hernandez, the remaining settings. So if we have the order of court setting that has the remaining dates on this case, so that, you know, there's never a question that he was informed of the hearing dates going forward, and we'll go from there. Okay.
Very well. Thank you, Your Honor.
Thank you, Mr. Nevarez.
Am I dismissed?
You're excused. Yes, sir.
Okay, thank you.